Jeff, please take over from here.
Okay, great. Welcome, everybody. Welcome to the COVID-19 era employment workplace issues webinar from Kozloff Stoudt. Thanks for taking the time to tune in. I hope this is useful for you. Joan London, my partner, and Courtney Berniker, my colleague, and I are going to present not fast and too furious, but just a fast review of the law that has changed over the last 2 weeks in order to try to keep you up to date with the changes. And with that, we'll go, let's dive in and move to the agenda. We have about 30 minutes that we're going to be clocked. I'm sure the master and commander of all webinars at Kozloff Stoudt, Mr. Becker, will be hovering and looking.
I'll try to keep you moving, Jeff.
Keep us true to time. So I'm aware of your presence, big brother.
Thanks, man.
So we have a really, we have a loaded agenda, and Joan and I are going to be addressing the issues that deal with the new laws and the tax credits. And we're going to try to do this in as efficient and easy way for you to absorb it as possible. We've made a great effort to try to keep things as simple as possible. So this is going to be just a fast overview. We're going to start with Families First Corona Response Act. Can you go back to that agenda, please, Courtney? Just 1 second. That acronym, and in fact, all of these acronyms, as you can see, are burdensome to try to remember and refer to. So the best way to keep the 3 laws that we're going to be talking about distinct is to just shorten them a little bit. All right. So the Families First Coronavirus Response Act, you'll hear and you'll see me speak to the CRA, or the Coronavirus Response Act. It's the big act. It's the one that was passed by the Congress first. It's the one that creates the other 2 acts. This law is not to be confused with the second big federal law that came down last week, the CARES Act, which is the subject of another couple of our webinars. All right. There are 2 parts to the presentation today. One is to focus on the expansion, the very narrow expansion to the existing FMLA, the Family and Medical Leave Act. And the other is to focus on the Emergency Paid Sick Leave Act. So we've got the Sick Leave Act, and we've got this expansion of FMLA. The tax credits are important for all of you to keep in mind. They are important because they're 100% dollar for dollar tax credits that your businesses are entitled to for the monies that you pay out in these paid leave circumstances. Okay. Now, when we get down to the end of the webinar, we're going to have a page that you can print out at your offices that has helpful internet links. You can activate those links. We can certainly help you and send them to you with the links activated, and then there'll be some frequently asked questions at the end. Please note that the links are not active. So when you try to click on them as we go through the link site, don't worry about that. We just have kept them inactive. The entire slide deck will be published to the Kozloff Stoudt website after the webinar is completed, so you can get a hold of those. And you're welcome to call all of us, email all of us, text all of us. We can get you this deck of slides if it's helpful to you.
And Jeff, just to interrupt for 1 second, if they want it, we would ask that they would send us an email. It'd be a lot easier to do that, and that way we can email them the slides.
Absolutely. No, you should be able to get them. I think the idea, the way we put these together, is to make sure that you have some desktop hard copy piece or something you can put on your electronic desktop that you can easily refer to. And then you can move to the next slide. Let's jump into this. Okay, so first of all, this Coronavirus Response Act went into effect on April 1st. And it's a temporary law. In fact, all of these laws are temporary. They're intended by Congress to get us through this crisis, this public health care crisis. So you understand this law. It's a big law. It's not quite as big as the CARES Act, which is over 800 pages, but it covers a lot of issues. The non-bold print that I've set forth here on this slide, it just gives you an idea of what is being covered by this law. It's covering school lunches expansion. It's covering SNAP and WIC, the Women Infant Care statutes that have been previously addressed by Congress. It's covering child nutritional programs, and it's covering, of course, medical leave, sick leave, and unemployment expansion and stabilization. We have 10 million, 8 million, 10 million unemployed people right now. The funding for all of this has been fed into the federal coffers by this act, okay? In bold at the bottom of this slide, the primary purpose and the focus of this CRA and the legislative purpose is to do two things. Three, really, the three things you're looking at there. It's to expand the Federal Family and Medical Leave Act, and it is to create a paid sick leave, and then to credit employers and businesses when they pay those monies out. Okay, next slide. So before we can get into the expansion of the FMLA, I wanted to just remind you, and many of you, if not most of you, will have already had your fill of the FMLA or digested all of its eligibility requirements. Remember what we're talking about with the FMLA, okay? The FMLA provides 12 weeks of unpaid leave. That has been around since 1993, and it covers eligible employees who fit into the category of eligibility that I've mentioned there, which you are familiar with. The process has long been the process has long been, I'm trying to use a non-lawyer word, excuse my delay. The process has long been focused on employers with 50 or more employees, all right? That's changed with regard to the Expansion Act. The Expansion Act did not change FMLA, it just changed the expansion protections and made those applicable to a broader number of employees, all right? Remember the FMLA categories of coverage. The FMLA remains in effect. These are the categories that are covered by the FMLA. And keep in mind that the Department of Labor enforces these laws. The FMLA and all of these coverage issues and all these eligibility issues, the certification viability, just as it always has. This does not change, okay? This is not going to change. All right. Now, let's move down into the rabbit hole a little bit deeper and talk about how the FMLA was expanded, all right? Okay, so first of all, everybody should either know this already or have some sense that this CRA, the Coronavirus Response Act, has opened up a world of coverage for businesses with less than 500 employees. That's most of small businesses. And again, that means as to this expansion that we're going to talk about here in just a minute, the coverage applies not to 50 or more employees. It actually reverses the perspective and it looks down from 500. So anyone that has 500 employees or less is going to be required to comport with this expansion of the FMLA. The procedures have changed a little bit, but for the most part, you're going to want to keep your FMLA processing concepts in the back of your mind, all right? The employer of an employee who is a healthcare provider, I'm gonna say that one more time, this is an important, it feels like someone has been left out, but that's not the case. So this new expansion does not apply to healthcare providers and to emergency responders or first offenders. It does not mean that they are being mistreated. It means that Congress has already decided that and already knows, and all of the people and all of the investigative purposes and powers that have gone into creating this law realize that healthcare providers and emergency responders are already covered either in the law or under their own CBA, collective bargaining agreements. And for the most part, they are essential, and they're not losing their work. They're still working. They're not going to be until they get sick with these. But for the most part, this law and these matters that we're talking about today do not apply to these two components. Doesn't mean they don't apply to municipalities, and Joan will mention that a bit, but it does mean that there are specific exceptions. So if you are a medical practice, or if you are a fire company, or if you are an EMT, these laws are going to apply differently, and frankly, not to your workplaces. Nobody's healthcare is in jeopardy under this law. And again, I'm mentioning to you that tax credit, which is going to be addressed later in our presentation. Okay, next slide. Thanks, Courtney. All right, so let's get to exactly how this Expansion Act is going to work. If you actually read what I've highlighted in that first paragraph, you are reading the essence of the expansion. And again, think back to my earlier slide where I laid out the qualifying conditions for FMLA. All right, so FMLA, you'll recall, it covers the classical birth of a child, care for a spouse, care for a parent, some other family or familiar circumstances who are suffering from, or if you are suffering from a serious health condition, they contemplate intermittent leave. Added to that list is this component. You are unable to work, and that includes unable to work remotely due to the need to care for a child under the age of 18 years old whose school or daycare provider has closed due to the COVID-19 crisis. It's a very narrowly drawn leave component. And again, it's an interesting one because before April 1st, people were home. People were home working. Our office has been home working for several weeks now, well back into the middle or early part of March. And children, you may or may not recall, were sent home from schools beginning some at the end of February, some in the early parts of March. So the question becomes whether or not the actual leave need is in fact provably related to this bold language. If somebody has already been home working, they may have already had a child home. They may have already had a 16 or 17-year-old home. They may be working fine and completely at home. So when they ask after April 1st, I want my Family and Medical Leave Expansion Act leave, you've got to ask them what's changed. Are you doing something different at work? Meaning you're home, remote work. If you're at work and they need to go home, then it's an easier and a completely different issue. So what do you get? You get 12 weeks of FMLA coverage for this, just like all of those other conditions. You also get the paid leave piece of this for the last 10 weeks. I'm sorry, yes, the last 10 weeks. Now remember, the statute is contemplating a week as a 5-day work week. So when we talk about weeks, we're talking about a full-time 5-day work week. And when the law speaks to the first 10 days are unpaid, they're saying the first 2 weeks are unpaid, or the first 10 days of employment out on leave are not paid FMLA time. That doesn't mean that the employee cannot elect their paid time off, their accrued vacation. They may do that at their election. You can't make them do it. They can go out unpaid for that 2 weeks. And in fact, there is a dovetail, there is a blend where they may be out, and you'll hear about this in a minute, where they may be out on FMLA and on sick time. So they may be home taking care of their under 18 child, but they may also be out sick with COVID-19 symptoms. So be mindful that the first 2 weeks of this Family and Medical Leave Expansion Act, also called the Expansion Act, okay, are not paid unless the employee elects to use his or her PTO. The last 10-week period is paid leave, and you have to pay them their leave in whatever, however you, it's basically 2/3 of the employee's regular rate of pay, but it's capped, right? It comes up to and hits $200 per day, and that's the cap that the statute requires. So these are easy arithmetic matters. And also, it's just for the 2 weeks. So do the math. $200 a day, 5-day work week, $1,000 a week, 2 weeks, first 2 weeks, or 10 weeks rather, is $10,000. Yeah, my math skills suffer too. There's a little asterisk there. It just says we're going to talk about this $200 a day in the context of sick leave. I don't want to confuse you by what $200 a day is under the sick leave statute and what $200 a day under this very limited expansion act is. All right, next slide. So let's talk about a couple of the waivers that are built into this statute. And again, for very small businesses, for businesses with less than 10 employees, for businesses under 25 employees, and for businesses with less than 50 employees, there are some built-in safety nets or relief valves, if you will. But you've got to be careful to address the specific language of the limitations. All right, let's talk about the first one here. So the first one, this first point says provides for a hardship exemption for employers under 50 employees. So if you're a small business, we're back to the 50 employee figure. If you're smaller than 50 employees, you've got 25 employees, you've got 10 employees, all right? And now remember, you've got to overlay that with the way the statute originally reads. Every employer with 500 or less, all the way down to 1, is covered by this law. What this is building in is the bankruptcy exception, the viability of your business exception. I am required to provide this leave to my employees, provided that the imposition of these requirements does not put me out of business. And this is the language in italics here that's critical for you to focus on. If you're not going to do this, if you're going to try to elect to step away from this obligation, this is the only relief you have. You must argue, I'm under 50 employees, and the imposition of these obligations to my employees on leave who might otherwise be able and eligible to receive this leave is that it will jeopardize the viability of the business as a going concern. That is talking about money. You can't put yourself out of business. Now, I may have mentioned this. I intended to mention it. If I haven't, I apologize. These statutory provisions are all interpreted and expanded and defined by regulations that are coming. Some have already started to flow from the Department of Labor. The statute says that the Department of Labor, and to some extent the Department of Health and Human Services at the federal level, are responsible for generating these regulations, which are going to give us all. They're going to give the lawyers, and they're going to give the employers, they're going to give employees, to the extent that they go read this stuff, a lot of information about exactly how this is going to work, and what is meant by jeopardize, and what is meant by viability of the business. Right now, we're all using our own experiences and our knowledge of prior laws, particularly the FMLA, to understand some of these concepts, but they're going to be clarified, all right? So let me shift to the other end of this leave, all right? So you have an employee who leaves the workplace, goes out on CRA, expansion FMLA coverage. They're paid for that 10 weeks. They are at the end of their leave, right? They have the 12 weeks of protected leave status, just like in the FMLA. And they want to be restored to their workplace. They want to come back to work, all right? Again, this is a relief valve. It is a small business recognition by Congress. It is a recognition by Congress that there may not be a business to come back to at the end of 12 weeks. And these are the way that for less than 25 employees, exception to the return to work, the restoration is what that is called about, is looked at, all right? If there is not a job in 12 weeks, which is 3 months, because we're still bogged down in COVID-19 public health crisis and businesses haven't reopened, God forbid, this gives you the, I don't have a job for you, all right? And what happens to that person when there is no more work, or that first job existent point is met and they're off FMLA? You don't have a job. That's going to put them into an unemployed status because they're no longer on leave. There are other categories here. The job no longer exists due to changes in operating conditions. Again, vagary. That is a very odd, very broad language description, but you can use your imagination. What does that mean? That means that the way we do business, the number of widgets that we produce, the number of lines that we have open, the number of shifts that we're running, the number of supervisors that I have in place, the number of gloves and protective circumstances that I have, anything that is operational that is in your workplace, if it is not able to cover that return, there is a potential reason for avoiding restoration, all right? The job no longer exists due to the public health emergency. How bad a scenario can that possibly be? Meaning we're still on lockdown, businesses are still shut down, or you have finally reached the point, the zenith, where you can no longer do any business. These are all end of, these are all, let's see, what shall we call these? We shall call these end of times circumstances, all right? Armageddon circumstances. That would be the worst case scenario, but that's what's built in here. Okay, next slide. This notice is required by the Act, all right? There's and can you jump ahead real quick, Courtney, and then come back to this slide? This is the notice. Some of you may have it already. It's available on the Department of Labor site. It's available on our Helpful Link site. It's available on the Kozloff Stoudt website. This poster is produced by, if you look down in the right-hand corner, or my other right, if you look down there in the left-hand corner, the Wage and Hour Division of the United States Department of Labor, all right? All of their contact information is there, conveniently for your employees or for employees who believe their rights are being violated under this law, to make direct contact directly into the Department of Labor. This is unusual, but it's not like it's never happened before. Most employers already have that big 3-foot by 2-foot red, white, and blue laminated federal and workplace rights poster. They're posted conspicuously in your common areas and on your bulletin boards. And it does this very same thing. It reveals all of the rights under all of the federal laws, all of the federal civil rights, and how to get in contact with the appropriate agency that's charged with enforcement of these rights. Do not freak out about this poster, all right? Mostly, I would look at this poster as a helpful explanation of what is covered by these two laws. How do I compute it? If there are questions, it's all kind of laid out there in rudimentary, non-lawyer language for the employee to read it and try to understand it. It may spawn questions. Hopefully those questions come to you, into your HR departments, come into your personnel departments, and they don't feed them out into the Department of Labor, which is what never, in my opinion, is the best first or starting point. All right. So let's go back. Let me just go back to the poster slide right before this. If you go drop your eyes right to about 3/4 of the way down, this poster is available in Spanish and English. All right. You're not required to post it in Spanish and English, but I would recommend to you that you publish it in Spanish and English. It is an 8.5 by 11 color poster that you can print off on your color printer and stick it up on the wall with a thumbtack, or otherwise secure it there. You ought to put the Spanish edition side by side with the English edition. And again, these are temporary laws that we're talking about. Come the end of June, they'll either expand all of it, or come the end of the year, they'll, not the end of June, come the end of December, they'll either expand all of these because we're deep in the quagmire of pandemic crisis still, or this will all be over, all right? Which means these leave provisions are temporary, all right? So remember, this is a required poster. It's a poster that the Department of Labor has published already. No, I did not create this poster. This is what the statute says will be done by the Department of Labor. The statute says that you look at that first language up there, the first bullet point, employers must post a notice, period. All right, and here's the broad language too, where notices to employees are customarily posted. These are not customarily posted in bathrooms. They're not customarily posted behind lockers. They're customarily posted in common areas, lunch break areas where people actually see them. So that's enough about the poster requirement. Let's go to the enforcement. Again, if you've worked with me and you've had a claim made to the EEOC or to the Department of Labor or to the National Labor Relations Board, you understand a little bit about what enforcement means. What enforcement means in the context of these workplace federal laws is that employees have rights to go to these enforcement agencies like the Department of Labor, who is the enforcement agency for this law. And they can claim or complain to these agency personnel that they're being mistreated or their rights are violated. What happens when that happens? What happens is that the Department of Labor, in this case, will assign an investigator who will reach out to you with a pleasant comment that says, a complaint's been lodged against you and we're investigating it. You may not treat people discriminatorily or retaliate against them because they are making these rights assertions. All right, so you've got to be careful about that. If you're not sure about where you're going with the decisions you're making, please call me. Please call Joan. Please call Courtney. These are not complicated. We have spent an awful lot of time in the last 3 or 4 weeks trying to understand these laws. I assure you that we will find a workaround, or we will make sure that whatever your obligations are known to you. You don't want to be in this particular soup. Okay, at this point in time, I think my part of our webinar is at an end. And without further ado, and to keep us on schedule, I'm going to pass the baton to my colleague, Joan London, who's going to talk to you about the Emergency Paid Sick Leave Act. Joan, take it away.
Thank you, Jeff.
Who would have ever thought, but here we are, and we'll help you. We'll get through this together. My first topic is the Emergency Paid Sick Leave Act. And Courtney, do you have the slide up? Okay. That too was signed into law on March 18th, 2020 and effective on April 1st last week. And like the family leave expansion, it will remain in effect until December 31st, 2020. It also covers what are small businesses, which are businesses of less than 500 employees, as well as our local governments, employers, and municipal authorities, which are among the participants in this webinar, regardless of the number of employees. Businesses count all part-time and full-time employees at all locations in the United States and U.S. territories. And that includes employees on leave, and that includes day and temporary laborers. Independent contractors are not, however, counted. Public sector healthcare workers and emergency responders may be excluded from paid sick leave. And just like with the family law, with the family leave exception, there are hardship exceptions, which in some cases are available for employers of less than 50 employees, especially when the reason is a solely childcare related one. The EPSLA requires up to 80 hours of paid sick leave for 6 specified COVID-19 related conditions. Full-time employees are entitled up to 10 days, 80 hours assumes 10 days at 8 hours per day. For full-time employees of paid sick leave time immediately for a covered purpose, regardless of how long the employee has been employed. Part-time employees must be provided with hours equal to how long the employee has been employed. Part-time employees must be provided with hours equal to what the employee works on average in a 2-week period, and we'll talk about in a moment as to how that's calculated. There must be work available, and the employee must be unable to work from home in order to take emergency paid sick leave. Courtney, can you go to the next slide? Okay, there are 6 qualifying COVID-19 related conditions for job protected paid leave, and that is where the employee first is subject to a government quarantine or isolation order. 2, if the person has been advised by a healthcare provider to self-isolate or self-quarantine, or it's a person who has experienced symptoms of COVID-19 and is seeking diagnosis, such as an individual who has gone to the doctor, been tested, and awaiting results. Go to the next slide. There are 3 other reasons. Another reason is when the employee is caring for an individual subject to self-quarantine or self-isolation, or has been advised by a healthcare provider to self-isolate or self-quarantine. That can be a parent or spouse or child who is sick with COVID-19 or suspected of having it, or an individual who is elderly or has a pre-existing condition rendering him or her vulnerable. The next reason, number 5, is an employee caring for his or her own child because the child's school or daycare is closed or childcare is unavailable due to COVID-19. For example, in Pennsylvania, as Jeff pointed out, the schools and many daycares have been closed for at least the last 2 or 3 weeks, some longer, and will remain closed for the foreseeable future. So this presents childcare challenges for many working parents. And the final qualifying condition is a catch-all of any other substantially similar condition specified by the Department of Health and Human Services in conjunction with the Secretary of the Treasury and the Secretary of Labor. To date, no such conditions have been identified. Go into the next slide, Courtney. Okay, there is a method of determination of compensation under the EPSLA. In determining EPSLA compensation, employers must pay the appropriate wage rate, which is the higher of the employee's regular pay rate or the state or federal minimum wage rate based on the number of hours the employee would otherwise be scheduled to work over a 2-week period. There's guidance in the regulations for calculating the applicable rate of pay for part-time employees with varying schedules. The employee first calculates the average number of hours the employee was scheduled per day over the 6 months prior to the date the employee would begin taking the paid sick leave. Once the employer calculates the daily average, it multiplies the number by 14 to get the 2-week average. You, as the employer, look at calendar days, not just work days in this calculation. Go to the next slide. The employer is due 100% of the required rate of pay for those first 3 reasons, which are called reasons personal to the employee's condition, which means that if the employee is either under a quarantine or isolation order or under medical advice to self-quarantine or self-isolate, or is awaiting a diagnosis after reporting symptoms, in those cases, the employee is due 100% of the required rate of pay. And the pay in this circumstance is capped at $511 per day, or in total $5,110. Go to the next slide. When the reason for taking leave is what we'll call care of another person, the last 3 reasons, an individual subject to a quarantine order or child care issues, then the total pay is capped at $200 per day, or $2,000 in total, based on 2 weeks of work, 10 business days. As a reminder, Jeff talked about the expansion of FMLA, which provides paid family leave for weeks 3 to 12. This is paid sick leave for weeks 1 and 2 of the 12 weeks. There's a capped amount here of $10,000 for 10 weeks, or $1,000 per week under the FMLA. And it's important to avoid confusion between the paid sick leave of EPSLA, which is available if you're unable to work or telework, or the family and medical leave entitlement. Now I'd like to talk about the tax credits briefly for employers. Eligible employers, which does not include governmental employers, so this is very much an unfunded liability to local governments, but may include self-employed individuals when the individual is unable to work due to this COVID-19 crisis, are entitled to refundable tax credits for qualified leave wages. The eligible employer is entitled to a fully refundable tax credit equal to the required paid sick leave. The tax credit also includes the eligible employee's share of the Medicare tax imposed on those wages and allocable cost of maintaining a health insurance coverage for the employee during the employee's sick leave. Could you go to the next slide? Okay, eligible employers are entitled to claim the refundable tax credits. Are businesses that, just like with the paid sick leave and medical and FMLA, are small businesses with less than 500 employees and are required under FFCRA to pay qualified sick leave wages or qualified family leave wages. And the guidance regarding who is an eligible employer continues to be published and updated. So keep in close touch with your lawyer and with your accountant on these matters. Qualified sick leave wages are wages that the FFCRA requires an employer to pay an employee who cannot work or telework because of the employee's health status, or because that employee is having to care for someone else whose health status is impacted by COVID-19. Qualified family leave wages are wages that an employer is required to pay under FFCRA because the employee is caring for a child whose school or daycare is unavailable due to COVID-19. Go to the next slide. The credit is allowed against the Social Security taxes imposed by Section 3111A of the Internal Revenue Code on all wages and compensation paid to employees. If the amount of the tax credit, that fully refundable tax credit referenced on the slide, exceeds the employer portion of these federal employment taxes, then the excess is treated as an overpayment and is refunded to the employer. Go to the next slide. Okay, an amount equal to the credit does not need to be deposited with the IRS with quarterly taxes, and that's to allow for conservation of cash in these times when many businesses aren't open or have to cut operations considerably. If there is a need for advance payment of tax from the IRS, if the employer believes that that is going to occur under this, that may be filed with the, if the federal taxes yet to be deposited are insufficient to cover the cost of qualified leave wages. For that, use the form 7200 from the IRS, and you see that there is a fax number on there. And go to the next slide. Record keeping is a must. You see on here the documents that you will need to keep and retain on employee leave, on and on payroll, including the qualified health plan expenses, so you have the allocable share. But there's a list of the documents that are needed. Remember, this is very much a work in progress. The IRS is continuing to publish guidance as this evolves. And it is important to, again, your attorney and your accountants will be a tremendous resource, but doing your part is to make their jobs easier by careful record keeping. Why don't you go to the next slide on some helpful links to know? Okay, first of all, we have our firm website, www.kozloffstoudt.com, and you also have the email addresses and phone numbers on this presentation for the three of us. You know, again, we are happy to talk to you, happy to help. Please call us or contact us by email with any questions that you have. You see the IRS and Department of Labor and the Form 7200. You have links to that on here, and those are extremely important to know. We didn't talk about unemployment. However, there is expanded employment compensation benefits available under emergency regulations, and on the Labor and Industry website, uc.pa.gov, there are frequently asked questions for employers regarding COVID-19, enhanced benefits available, the waiting week and work search requirements are temporarily suspended. And you want to look at that website as well, because in the unfortunate event of layoffs or furloughs, employees will be eligible for unemployment, and they'll have questions, and you will also have questions about it. And with that, I'll turn it back over to Jeff. We'll talk about some frequently asked questions and questions that you may have.
I've got to be unmuted first.
You're unmuted. So let's just talk a little bit about some questions. If people have questions, if any of the attendees have questions, you can go and raise your hand and I can unmute you and you can ask your question. Or if you would like to just ask the question by sending it through the webinar chat, we will relay the question to the appropriate speaker. So if anybody has any questions, please just raise your hand and we'll try to work through those questions. Doesn't look like we have anybody coming in right now.
That's all right. In the meantime, we can work through some of our questions.
Well,
maybe
sure.
Some of our questions will cover their questions.
Okay, let's do that.
So again, we're getting near the end here. I just wanted to include I wanted to make sure I included some of the questions that are coming in. What Joan and Courtney and I have been doing for the last 2 weeks is keeping a track of the questions or actual questions that are coming into our office or into our home offices. So let's just jump in here for a second. First, regarding the new laws, would an employee who continues to work regular hours but at reduced pay be able to apply for unemployment compensation? That's a really important piece, and you're going to track on the answer to this if you go to the Pennsylvania Unemployment Compensation or the Department of Labor and Industry site. It isn't reduced pay, which many companies have done. So many businesses are pulling back to percentages of pay rather than cutting back hours. Unemployment compensation is about hours cut. So if you are contemplating reducing pay, you're not going to trigger an unemployment compensation benefits petition for that employee who is obviously losing income because they're not losing hours. So you need to actually contemplate that on the other side of the issue, which is reduce the hours to affect the reduction in pay. And then there's a delta, there's a differential there between the two pay, and that is going to be covered by unemployment compensation, which, as Joan suggested to you, under the new CARES Act, unemployment has lost its waiting period. It has become a little bit overburdened it's become a lot overburdened, frankly, in my opinion, based on what I'm hearing, because of the volume of applications, electronically, by telephone, online. But it doesn't mean that those retroactive payments won't be forthcoming. So keep that in mind as you contemplate making changes in your workplace. In the furlough context, which is we've got to pull people back. We send them home. They're not working, but they're sitting at home. They are going to be covered by unemployment compensation. When you pull their time back, they're covered by unemployment compensation. When you just reduce their pay, they're not. All right.
Jeff, something else to know about with unemployment is the work sharing program that is detailed on the unemployment compensation website, which allows for the distribution of hours among 2 or more employees. And with that reduction, allows the employees to collect unemployment for the remainder or to make up that difference. And there is some relief for the employer as well. The employer's experience rating or unemployment tax is not going to be increased due to layoffs or furloughs due to COVID-19, which is an important feature of some of the measures taken.
Understood.
And
Okay,
Jeff, I just got a question here, Jeff. Question wanted to know, to whom does the Emergency Family Medical Leave Act apply? And they asked that, but can you kind of briefly just kind of give that summary? To whom does that apply? And I think what they mean by that is it every employee is eligible for that, or is it just certain employees that are eligible?
It's all employees. So anybody that would be owners, shareholders, it's very simply worded, and it's temporary. So there may be some subtle changes between, where FMLA defines employee in the past, but for purposes of this narrow expansion of FMLA, under the conditions defined by the statute for this expansion, just in the context of being at home to care for children under the age of 18, employees are employees, very broadly defined. All right. Okay. I talked to you about the poster. Again, I've had more questions about that than I have fingers on my hands. Everybody wants to know if they've got to put this poster up. Yes, the statute makes that clear. The poster's got to be posted in your workplace. The next question is about 13 employees. We covered that. I may have spent a little bit too much time on that waiver, that exception. If you are dropping down under 25, under 50 employees, and you have hardship to try to engage in these obligations, 2 things are going to be triggered. All right, you drop under 50 employees, you're going to have an exception if the viability of your business is the question. All right, so don't bankrupt yourself paying out these leave and paid sick time obligations. That's not the intention of the law. And it isn't arbitrary that 50 number of employees is picked by Congress. We've seen that before. We've seen it with regard to the FMLA. So they don't want to work hardships, not that we aren't all suffering hardships right now, and employees are all suffering hardships right now for most of America. But when you drop, if there's a 13 employee firm or business and you're trying to contemplate these payments and they are going to cause more harm to your business than they would do good for the employees, there are exceptions there for you, all right? What if the employee's been teleworking? I talked to you about this a little bit, perhaps a little bit in passing. But remember, you've already got an employee who's been out with their children at home because their schools are closed, but they're working. That's going to create a factual issue about whether or not they are now home after April 1st because of the closure of the school. So these are fact specific scenarios. Again, I'm very comfortable because I've seen a lot of laws, and the way that a lot of laws are drafted, it's very difficult for non-lawyer average citizens who want to do right to read and understand. This law isn't like this, all right? These laws are pretty clear. They make it very, very clear. So don't if you've got questions, bring them to us, but don't struggle with with this on your own. The answers are out there. All right, and we're going to get more clarification when these regulations start moving freely. And they're expected to keep coming now, I would say through the month of April at least. Okay, next slide. Let's see. My employee was laid off 2 weeks before the effective date. This is another interesting subtlety. If you think about it, once I've given you the scenario, it makes sense, all right? My employee was laid off 2 weeks before the effective date. So that means back in March, I laid people off and is home without pay. Now I brought her back and she's rehired after April 1st. And she may be ill, or she may have someone at home who is ill. So she would necessarily start falling into the eligible employee circumstances. She may have children who are, daycare issues have created. Maybe not the schools, but she's lost a daycare provider. Maybe to the disease, maybe because of the disease.
Jeff, I've got two questions, related questions.
Let me get through this. Get through this. It's 2 more sentences. When that individual comes back to work, she is not subject to the 30-day employment standard because she's already been your employee. All right, the law contemplates that. I have an employee who has worked for me for a long time, certainly at least 30 days. She leaves the workplace on unpaid leave before April 1st. She comes back in, she doesn't have to work 30 days to be covered by these laws. All right, Joan, go ahead.
Yes, the question I have is, if an employee requests pay for staying home to watch a grandchild, as both parents are working in critical positions, nurse, etc., is that allowed under the CARES Act? And I'm looking at the Employee Paid Sick Leave Act, and that refers to caring for his or her child because the child's school or daycare is closed or childcare is unavailable due to COVID-19. I think
the question is whether can both parents be out and collect leave simultaneously? Is that the question?
Well, no, this is a grandparent asking the question because they've been asked to watch a grandchild. The grandchild's child care is unavailable, assumedly due to COVID-19, but the parents are healthcare workers. And the question is whether under the CARES Act that expanded family leave would be available. Under the Expanded Sick Leave Act, it wouldn't be because it would be to care for his or her child. And most likely for the parents themselves, it wouldn't be available because if the parents are both healthcare workers in a critical position, they may be exempt. So the question is that under expanded family leave, then would it be possible that caring for a grandchild, assumedly one not in their custody, would be a qualified reason for paid leave? And I don't believe it would be.
No, the short answer is no. And again, they may tweak that a little bit with the regulations, but right now, if you recall the slide that I had for you, the coverage for the expanded, the amendment to the FMLA says the following: unable to work due to the need to care for a child. All right. Now, right now, the way that I'm reading that and the way that the preliminary regs cover this, it's your child, your home, caring for your child who's no longer at home. It doesn't contemplate you as a daycare provider. So that could actually be interpreted similar to FMLA. I think FMLA's expansion of those types of definitions gives some leeway to contemplate your scenario. But the way I read this law today, this is very focused on benefits for employees only. All right. If the regs change it, then we'll know, and we can certainly, answer the law, advise you that the word child or the word the child applies to you as a grandparent or applies to you as a daycare provider. But this law is not intended to give daycare providers and relatives who are caring for children coverage under the FMLA for that expanded leave. It is intended to provide the worker, the employee, that protection.
I agree.
So Jeff, I have a couple questions that are coming in here. Let me ask you. First one is, we have an employer who's laid some people off previously. And then the question that comes out of that is the FFCRA notice that has to be sent out to the employees. Do you send that only to the active employees, or do you have to send it to people that were laid off too?
We're not talking about sending the notice. We're talking about posting the notice.
Do you have, well, maybe let me ask this question. Do you also have to send that notice or give the employees, the active employees, that notice?
No, this requires very literally, again, this is literal language right from the statute. The statute says, requires certain employers, that's most employers, to provide their employees with paid sick leave. Let me actually just give me 30 seconds. Let me just read the language out of the actual statute so I can be very clear with this, because I don't want to create any confusion.
Okay.
Hold on.
While you're getting that, and we're looking at your materials there, Jeffrey, let me ask another question, and maybe Joan, you can help out with this, or maybe I can as well. If a temporary laid off employee files for unemployment and elects to get paid accrued vacation, does that affect their regular state UC benefit or the $600 pandemic benefit?
I can answer that. Yes, it does. If you go to the unemployment website on expanded benefits for COVID-19, it makes it clear that the employee should first exhaust their paid benefits, because that is at 100% of their salary versus unemployment, which is capped at a percentage of salary. So until you're not being paid, you would not go to collect unemployment.
Okay, thank you.
Okay, can I jump in, Dan?
Yep, please, absolutely.
I'm just typing an answer real quick. So let's go back to the original question that was asked about the notice. The notice language says each employer shall post and keep posted in a conspicuous place on the premises of the employer where notices to employees are customarily posted. A notice to be created and approved by the Secretary of Labor that sets forth these qualifications, blah, blah, blah. This poster does not have to be printed and hand delivered or distributed anywhere except in your workplace. One time. It doesn't say post it repeatedly every month, revisit. It says put it up in a conspicuous place where you customarily put such posters. That's it.
So Jeff, in this particular, in this particular instance, Jeff, I think what the employer in this situation was saying was about 90% of their workforce is working remotely. So they wanted to make, so that's
Post it
why
on the website then.
they actually send it by email, which makes sense.
Okay,
They can
that means
accomplish.
it's floating around. Again, you're not gonna, what I would say is there's no harm in the, I don't have any problem with that.
Right, right.
But I will tell you also that notices create questions and give direction to employees, in my experience, to go places first where they shouldn't. They should bring their questions first to you. They should come first to your HR department. They should ask for your help. They should not go to, not only is it going to bog the system down if they're just asking, how do I do this? But it's also going to create issues of enforcement and issues of presumptive guilt, in my opinion. If you get that question from the Department of Labor that says, why are you mistreating this employee who's trying to get leave under the new act? All right, that's a question that you don't want to have to answer, and it's you know, it adheres the inherent you're guilty by the question is the problem that troubles me when employees go directly to the agencies first.
Okay, let me ask you another question here. There's another question that's come up, which is if you're currently working under the state of the law, and if this the stay-at-home orders and business continues to be restricted, can you lay people off? And what are the impacts under the EFMLA and the emergency sick leave? If they're on one of those two benefits and you lay them off, can you do that while they're on taking those benefits? Essentially what the question's asking. That makes sense.
No.
Okay, so I think the question is this. As I'm interpreting it, I think the question is this. Can you lay them off while they're on the Emergency Family Medical Leave Act benefit, or getting the sick leave benefit?
No, they're in a protected status.
Okay.
They're protected. You can't lay them off while they're on leave. Once you've put them in the leave, they're protected. Now, again, calamity tells us, right? Calamity tells us that if I collapse in on myself because I have 14, 15 employees out, and they're all being paid this leave, and I can't afford to do it anymore, and it collapses in on itself, and the payments are going to stop, and I'm going to have to lay people off, you're going to be triggering that jeopardizes the viability of my business as a going concern. So you can make that argument when that happens. It'll likely be difficult to make before you reach, you know, the edge of the cliff.
Okay, thank you. All right, if there's any other do you have anything else, Jeff or Joan, that you would like to present?
No, I think we've covered everything. I think have we gone through all the frequently asked questions, Joan?
We went through most of them. A lot of them were answered in your presentation.
Great. I think we're past our promised 30-minute webinar, which I'm loath to do because I've been listening to some of these hour-long and hour-and-a-half-long webinars, and they're miserable.
But everybody knows you knew, Jeff. Yeah. All right. Well, look, at this point, then I guess we'll wrap it up. Any final comments or statements from anybody, the panelists?
Thanks for the opportunity to talk with you, and you're not alone with answering these questions. Don't hesitate to call.
Yeah. So
right. Thank you for your attention.
What I would say to everybody that first, thank you again for attending today. The webinar will be available on our website shortly. And if you do have any questions, please reach out to any one of the panelists that are here today. The phone number is 610-670-2552, and you can leave a message or we'll get back to you right away. And we'll be happy to answer your questions. And we look forward to getting back to work and seeing you all again very soon. So thank you very much for your participation.
Stay healthy.
Yeah.